Assistant Attorney General and Senior Counsel for Forensic Litigation in that office. I actually handled the state side of the appellate case that led to all of this happening, and it's a good example of why the bill is necessary, because the Fry-Reed hearing took as long as the trial, if not longer, actually. It was a murder case, and it took them about 2.5 days to do the Fry-Reed hearing. It only took them about a day and a half to do the murder trial. The important issue is that the various crime labs that do DNA analysis in Maryland have to comply with the FBI quality assurance standards. It's how they get accredited, and they have to comply with them in order to participate in the CODIS database. So they can't adopt any different standard. They can't. The problem with the appellate decision that came in this is that the court suggested, oh, you have to follow the SWGDAM guidelines. Well, there are no such thing. These are recommendations only, and if the state labs started trying to follow them, they would risk their other accreditation, their FBI accreditation. So the standard proposed by the appellate court in the Phillips case is unworkable, and that's why the statute needs to be amended.
You said SWGDAM, those are...
right, SWGDAM, and I can defer to...
But those were not acceptable because they're only policies or guidelines?
Right, SWGDAM makes recommendations to the FBI. The FBI then issues its quality assurance standards incorporating those recommendations. But they are different things, and the issue in Phillips was there was this much daylight between the two. It had to do with a retroactive application of a particular standard. And the labs follow, because they have to, what the FBI says, even if it differs slightly from what the original SWGDAM recommendations were.
Okay, so we don't rely on SWGDAM because they're merely recommendations. We rely upon the actual policies
By the FBI quality assurance.
Right, thank you.
You are...
I'm Dan Katz. I'm the director of the Maryland State Police Forensic Science Division. I'm just here if there are any questions.
Gotcha. I think we got it. Thank you very much. Thank you all for testifying. We'll turn to the opposition. Steve Mercer.
Good afternoon. Thank you, Mr. Chairman. Steve Mercer, Chief Attorney of the Forensics Division at the Maryland Office of the Public Defender. This is not a cosmetic change or an update that's being proposed. It's taking a best practices statute and turning it into a it's good enough statute. That's unwarranted. Here's why. The original statute discusses TWGDAM and DAB. And then also the note that comes along with the bill discusses how TWGDAM became SWGDAM and DAB has grown into QAS. Well, the bill is only asking for QAS, leaving out SWGDAM. Now, here's the difference between SWGDAM and DAB, and it's discussed in the Phillips decision. SWGDAM applies to cutting-edge DNA methods. The quality assurance standards apply to what I'll call plain old DNA analysis. So by cutting out SWGDAM and just leaving in QAS, in effect, what would be happening is you're insulating, you're giving a pass to any testing of the cutting edge DNA as to its reliability, while allowing in, on a short track, plain old DNA testing, which doesn't need an admissibility hearing. So it doesn't make good sense, in my humble opinion, if you have cutting-edge DNA technology, which there is quite a bit of now all around us, and then you're given a pass to that, never having to establish its reliability, and then all of that's coming into trial. It's not a cosmetic change. It's unwarranted, and there should be more thought given to what standards should be adopted. Thank you.
Yes.
So I'm trying to understand what you're saying, but it seems like what you're saying is you don't have any problem with the language that's in there. You want to also keep in TWGDAM in addition to what's already there?
Well, SWGDAM.
SWGDAM, excuse me.
So the SWGDAM recommendations, let me give you an example. For example, the one cutting-edge area of DNA are interpreting complex mixtures of low-level DNA, touch DNA. Very like getting a DNA profile, mixture of DNA profiles from a steering wheel, doorknob, things like that, where the amount of DNA is so incredibly small, and that's possible now because of all the improvements in sensitivity. So the FBI quality assurance standards, when it comes to interpreting that mixture of of DNA simply says you have to have a procedure for doing so. Okay, it doesn't detail what that procedure should be. Then you go to SWGDAM, and then for these cutting edge areas, then SWGDAM has working groups, and SWGDAM are the federal, state, local forensic lab folks, right? And so SWGDAM develops these recommendations about how to interpret, for example, complex mixtures of DNA. And so if you're, and why is this important? Well, for example, in Maryland, you can have two labs that both follow QAS. But they have different interpretation guidelines. One may be more consistent with SWGDAM, the other isn't. You take the same data, one lab will say under SWGDAM, this is too complicated for us to come up with a reliable comparison. The other lab says it's an inclusion. We can't exclude the person and then generate some kind of statistic. I don't think that's what this bill is intended to insulate, right? I mean, this is as originally enacted, the legislature said, we'll give a pass if the DNA profile is created using the most rigorous, the most robust standards that exist. But now, by simply saying we're just going to use QAS, now, and Phillips, the decision discusses that, now you're just talking minimum standards, and where you have to address the cutting edge stuff is SWGDAM. You leave that out, well, now the stuff that really needs to have reliability tested is getting a pass. And that's just not what this statute ever intended.
So the other can come in, it just requires the additional steps. That's what you're...
Well, yes, the SWGDAM
Okay.
recommendations
Can still come in.
would be appropriate, but that is what I understand is the sponsor doesn't
Okay, thank you.
interest. Thank you.
All right, that concludes that for Senate Bill 637. Now turn to Senate Bill 922. Senator Ramirez,